All right, everybody. Thanks for joining. We're going to go ahead and get started. Today, anatomy of an M&A deal. That's what this webinar is about. And so we're hopefully going to get through all the slides here. We just have a broad overview of how an M&A deal works, and we're going to discuss some of the issues that pop up and just the process in general. That's the goal for today. This is one in a series of webinars that we're going to be putting together on M&A topics. So this is the first one, just kind of, again, going over a broad overview of the process of an M&A deal and how it works. And then we're going to delve into some of the other topics a little deeper. We have, hiring an investment banker or broker. We're going to talk about that in more detail. We're going to talk about LOIs in a separate webinar. We'll have a separate webinar on issues with due diligence. Then we'll have a webinar on purchase and sale agreements. Asset purchase agreements, most likely is what we'll focus on. And we'll go through the reps, warranties, indemnification provisions, because those are hotly negotiated topics in an M&A deal. And then we'll have a webinar on state and local tax issues in M&A. And if there's any other topics that you think would be good to learn about or that you guys would be interested in, please put it in the comments and just let me know, because I'm happy to present on anything that you guys are interested in. So if you have a question, feel free to I think there's a raise your hand button, and I can unmute you, or it might be easier actually just to go put it in the chat. I'll be monitoring the chat from time to time and making sure that I can answer questions there when they pop up. So go ahead and put anything in the chat and I'll just answer questions as we go. All right, let's get started. And we'll also have a separate section at the very end for Q&A, so we'll leave some time for that. So if anybody wants to save their question till the end, that's fine too. All right, anatomy of an M&A deal, process and team is kind of what we're mainly talking about here. First slide, I just have a little biography. This is me, attorney here at Doida Crow Legal, based in Denver. I graduated from Denver University Law School in 2009, and then received my LLM in taxation from the Denver University as well in 2010. Doida Crow Legal, we're a firm of business transactional attorneys. So we have 8 attorneys, and we focus on business transactions and representing entrepreneurs. And that typically comes in the form of representing buyers or sellers in the purchase or sale of businesses. But it also comes in the form of representing startup companies, preparing entity documents, doing securities work. So if somebody's raising equity, we help with navigate the securities laws, and then commercial contracts as part of that as well. Our goal is to become the go-to business transactional firm in the Rocky Mountain region. So that's where we're shooting for. As for today, here's the agenda. We're going to talk about introduction to the M&A process initially. We're going to talk about forming the team, starting the process. Talk a little bit about valuations. I'm not going to get in that too much, just kind of a broad overview of how valuations work and how I've seen that work. Sorry, there was my biography. I have multiple screens here, so I got to remember to move the slides along. Sorry about that. There's the biography slide. Here's the agenda. All right. So valuation is, like I said, we're going to briefly touch on that. We're going to talk about negotiating the deal. We'll talk about due diligence issues, closing the deal, and then post-closing matters. And then after that, we'll leave some time for a Q&A session. So, but like I said, if you have a question as we're going through, off of something that I'm talking about at the time, please feel free to put it in the chat. All right, let's get into it. Introduction to the M&A process. So, I say M&A is a process, and it really is. It's more of a process than anything else. So the process of, and it specifically is the process of transferring a business from one owner to a new owner. And, businesses are inherently complex, which makes M&A transactions inherently complex. And so I'm approaching this from the perspective of the type of deals that we work on. So, I know different size deals can lead to different complexities and can even lead to decisions on where you want to dig into those complexities or not, depending on the size. But the typical deals that we're working on are in the $1 to $50 million range. So I categorize that as the lower middle market deals. And typically that's on the buy side. I would say most of our transactions are in the $1 to $20 million range. And on the sell side, that's more on the $5 to $50 million range. And those are broad ranges, but once you get above that $1 million threshold, it usually becomes time to have sophisticated M&A counsel to help you with this and have other parties that are going to be involved. So when I say complex, if you think if I go back to my law school days, there's not really a law of M&A, right? It's not like intellectual property law or civil procedure or some of these other narrowly defined bodies of law, or even antitrust law or ERISA law. If there's attorneys out there that specialize in those type issues. M&A is really a mixture of many laws dealing with the transfer of business. So, as a simple example, just to kind of show you how this might be complex, is a business, say there's a business that wants to transfer one of its business, has multiple business lines, and it wants to transfer one of those business lines to a newly created subsidiary, and it wants to raise capital from investors for that new subsidiary. So it says, hey, this line of business, we think it could really succeed if we raise some more capital, but we have several lines of businesses, and we only want to raise capital for that one line. So this is a related party transaction, right? And it could be considered, it's a transfer of a business though. So you form the new entity and you transfer the assets over to that new subsidiary, or contribute the assets into that new subsidiary. And what issues can come up with that? I mean, one, that line of business probably has contracts, right? And so those contracts, are they assignable to this new entity? Are there change of control provisions or anything like that affect the ability to assign those contracts over to the new subsidiary? Is there intellectual property that needs to be assigned to that? Especially if you're going to be taking on investors in that new entity, they're going to want to know that the intellectual property is properly held in that business, and that it can use it and has either contracts to license that intellectual property or owns the intellectual property outright. What are the employment implications? Do you have employees that are focused on that line of business? How does that get transferred over? And then, what are the tax and accounting issues that are associated with that? How are you going to account for this moving forward? What are the tax consequences of transferring those assets into this new subsidiary? So you can see how it gets complex pretty quickly just on a simple related party transfer of a business. And so that's, again, why I say this is a process, and it's really inherently complex. But we'll get into the process of how we usually deal with these transactions. First off, we got forming a team. So you need to assemble a team, and this can occur at various stages in the M&A process. But my general statement on that is the earlier the better. And this presentation is kind of a broad, like I said, a broad presentation. So we're addressing kind of seller and buyer issues, but they're going to be different at every stage, and I'll try to point those out. But if you have any questions about that as we're going, let me know. So if you're forming a team on the initially you have an internal team, right? So if you're a seller, it's who should know on the internal team. Is it just the founders? Is it just the C-level executives? Is it C-level executives and key employees? Who should know that you're looking at embarking on a sale process? Because you don't want the rumor mill to start going around. And so deciding who's going to be your internal team is very important. On the buy side, it's similarly important. If you're an existing company that's looking to bolt on another business, you want to potentially limit the people who know that you're out there looking for other businesses. And so you can have the appropriate messaging to all the employees when you do acquire a business or on the precipice of acquiring another business. Or if it could be an independent sponsors type situation where you're an individual business and an individual who wants to buy a business and you're going out to have investors. So then do you want to get your investors involved? The search fund type model situation or other independent sponsor model where you might have investors involved to close on a deal. At what point in the process do you want to get them involved on the type of business that you're looking for? So first you have the internal team. Then you have investment advisors or brokers. And so on the sell side, a investment advisor is going to assist with the seller to better understand the business and how to package it up to sell the business, right? And so And this will they'll also, once they're ready to sell or have it packaged up and to sell, they're going to identify the potential buyers. They're going to qualify those potential buyers. And on the sell side, advisor is also going to be able to help the seller understand and distinguish between competing offers, right? So they may receive several LOIs to purchase the business when you get to the sale process. And so that sell side advisor hopefully can help advise on what structure might be better and how to structure the deal moving forward. On the buy side, these are more rare. On the buy side, there's fewer investment bankers and business brokers out there that want to deal on the buy side, right? They like to get listings and sell the business, and then they get paid as a percentage of the sale proceeds as a success fee when they actually sell the business, right? So that, I would say, it's more rare to have a buy side investment banker or a business broker. Yeah, it does make good sense to contact those people, I think, even on the buy side, because they will help, funnel deals to you. They usually are trying to sell their own deals to you, so they can get the commission right when they sell it. But that is one access to pipeline that you might want to look at. And so, the question that I get a lot of times is, when do you use a business broker versus using an investment banker? Business brokers typically, at least in Colorado, only have to have a real estate license. They don't have to have any securities licenses at all. Whereas investment bankers typically have securities licenses and in general are more sophisticated in the financial terms of businesses and reviewing those and helping package the deals. And I think it really comes down to the size of the transaction. Under 10 million, business brokers are typically dealing with deals under 10 million, I would say. There's probably an overlap between investment bankers and business brokers in that $8 to $15 million range. And then above $15 million range, I would say you're typically looking at an investment banker, or at least a business broker that has a securities license. So, we're going to have a separate session just on, looking and hiring a sell-side advisor. But I think just to throw out a few questions here, if you are looking for a sell-side advisor, some of the questions to ask are, what is their process for marketing the business and qualifying potential buyers? How do they do that? And listening and really analyzing how they respond to that question. The other big question, I think, which helps qualify the sell-side advisor of whether they're going to be a good fit for your transaction, is how many deals have they done in your price range in the past couple of years. So, if you're selling your business for $7 million or $10 million, and they've only the potential broker on the deal has only done, laundromats for $200,000 in the past 2 years, they may not be the best fit for this deal. And then the other question, I think, is how do they assist in due diligence? Because you're going to find that varies a lot between sell-side advisors on how much they're going to actually assist with the due diligence process. So that's another question. On next part of your team is going to be legal advisors, right? So you have typically an M&A counsel that's going to help negotiate and draft the contracts that are involved, either the asset purchase agreement, stock purchase agreement, membership interest purchase agreement, however it's structured, as well as the other sort of ancillary documents that go with that. Is there going to be a seller note? Is there going to be a transition services agreement? Is there going to be a non-compete? All those ancillary documents that go along with an M&A transaction. And so you typically want to have somebody, your M&A counsel is experienced in doing M&A deals, but you may need other specialty counsel, right? So if it's a business that's highly regulated, like a cannabis business, for example, you might need regulatory counsel that understands the regulations, the MED regulations, or the recreational regulations, depending on the state where it operates. And so that may be necessary. If it's a very intellectual property heavy type business, you might need an intellectual property specialist to kind of review patents or understand how to transfer the patents and those sort of things. You may need, potentially real estate counsel if there's real estate involved. You may need special tax counsel if there's going to be if it's going to be structured in a way that tax is a big piece of it, which it's a big piece of every transaction. But if there's going to be some unique structure that we need to understand the tax, how it's going to be taxed as part of it, then that's an issue. Or it could be a state and local tax issue, right? Whether the selling company is collecting the appropriate sales and use taxes where it operates. You may need, depending on the number of employees, you may need an employment specialist, immigration, ERISA. If they operate in foreign countries, you might need foreign counsel. So there's a number of different specialty counsel that may need to get involved in an M&A deal, depending on how it's set up. Next, we have accountants, right? So typically you're going to have accountants that are involved. They assist with the tax planning, financial structuring. They may help prepare pro forma financials, that sort of thing. You also may have specialty shops that are really accountants, but they do a lot of other things like Q of E. So you might need a quality of earnings that may be conducted. The buyer, a lot of times the buyer is the one who's going to get a Q of E done on a potential business. But these days, I've seen sellers get the Q of E as well proactively. So they know they're going to sell their business as part of their preparation. They get a Q of E done for themselves, so they can kind of present that to the seller when they come in. You also may have a valuation firm, right? So it might be a specialty valuation firm that does, either values the business or particular assets of the business. If there's a heavy sort of equipment, we need equipment appraisals or something like that. If those are expensive pieces of equipment involved in the deal, you might need a special expert for that. Human resources is another one. Depending on how many people are involved, there may be some benefits consultants that you bring in to help, make sure that the benefit plans from the selling entity and the buying entity are gonna work, and all the employees understand it post-closing, how it's gonna work, and they're not getting something so dissimilar that they're going to be upset and quit. You want to make sure that that's kind of taken care of. Then you have, lenders. Lenders might be involved if there's going to be financing as part of for the buyer, debt financing. Then you're going to want to get, the buyer's going to want to get a hold of a lender early in the process, get them involved, get them the financials, get them all the information they need, so they're going to be able to close on time at the closing and bring the funds to the table. So that's another part of the team. And then you may just have other advisors. There may be risks, environmental consultants. There may be, you may have consultants for risk management. You may have insurance broker consultants to kind of come in and check that, how the insurance is set up and what transfers over, what doesn't, and what new insurance policies you need. So all these people can form a team in an M&A deal, and having at least access to those people early, I think, is important if you're going to embark on an M&A deal. All right, so starting the process. How does the process start? Well, first we got to understand who the stakeholders are. The other stakeholders, not the team that we just mentioned. We have other stakeholders that might be involved. The employees is the big one, right? So employees in the company understand how they're going to react, how you're going to message this to the employees if you're on the sell side, or even on the buy side, how you're going to come in and message this to them to say, hey, this is good for you, this acquisition, because we're taking the company to the next level. We're doing whatever we're going to do. But understanding the employees that are involved and the culture of the company is very important. Customers and suppliers, other stakeholders, right? So the selling company is going to likely have customers and suppliers, vendors, things like that. How do we understand the transfer of those relationships? So is there contracts in place? Is it just an informal relationship where there's purchase orders and things like that? We just want to make sure that that's all buttoned up, or at least we have an understanding of it, so you can address those issues when they come up. And this is where there might be anti-assignment clauses or change of control clauses in contracts that need to be reviewed to understand if we need third-party consents to transfer those contracts and those sort of things. Creditors of the seller, that's another stakeholder, right? So if the seller has a creditor or has a debt, especially if it's securing the assets of the company, then that's another piece of the deal that we got to understand. Are those going to get paid off at closing? Is it going to be, is there a possibility of assuming that debt? How is that all going to work? I would say in a typical asset purchase agreement, that's going to be that debt is going to be paid off and at closing. So part of the purchase price proceeds are going to go to that creditor to pay that debt off. And then you have landlords. Landlords are always a sticky issue. And I always say, when clients come in the door, my first, they say, when can we get this deal done? How long is this going to take? And I say, a lot of it depends on third parties. And typically I say it's not going to be us that are holding up the deal. The parties that hold up the deal are typically landlords and banks. And that's just my general experience, is that banks, are going to ask for something else at the last week of closing that they hadn't asked for before. And they're just not going to be focused on it. Sometimes aren't focused on the deal until it comes down to the last minute. And so both of those two third parties can throw a wrench in things, or at least postpone closing. Landlords, this is a lot of times landlords don't have much incentive to agree to an assignment, right? So if a seller has a lease and they want to assign it to the buyer in an asset transaction, then what incentive does the landlord have to do that? Now, if the buyer has a much bigger balance sheet and is a much more credit worthy, then hey, they do have an incentive to go ahead and assign that over, because they're pretty sure they're going to get paid by that much bigger company. But if it's a new buyer with not a big balance sheet, then they're going to be worried that this new buyer is going to come in and not be able to run the business, or it's going to fail, and they're not going to be able to pay. So a lot of times it takes some negotiation to get landlords to assign leases over. So that's always an issue. All right. So now, after we understand who the other stakeholders are, then we got to start planning for the sale or the purchase, right? So if you're on the sell side, it makes sense to start doing a pre-sale what I call a pre-sale examination of the company. So you want to look at the corporate side is one aspect of that. So how are the corporate books and records? Do you have entity documents in place? Who are the owners of the company? What sort of approval do we need to actually sell the company? And so we got to take a look at the entity documents and understand, if it's a single owner, it makes it real easy. You just need that single owner to approve, right? But if you have multiple investors or kind of a widely owned company, then you may need shareholder consent or member consent, depending on how the business is structured. And so you just want to understand how that's going to work. Environmental issues. If you have, dealing with environmental issues, then you want to try to flush those out early in the process. Labor employment issues. Do you have any, issues with that you need to look into? Supply chain issues. Especially now, this has been a hot topic for the past couple of years. Is there supply chain issues that we need to deal with? Are you a single source or a multi-source on your supply chain? Do you have, if China gets shut down, or do you have no more product? That's a potential issue for buyers, and buyers will try to discount the purchase price because of that. Sales and distribution. What do you have pricing and policies in place? Do you have contracts for sales and distribution? How does that work? Taking a look at that. Contract termination rights. Is there a big vendor or a major supplier that has an anti-assignment or change of control clause in there, and you're worried that they're going to consent to it? That's something to try to figure out early. And then IP issues. Has the IP all been assigned to the company? Does it actually own its IP? Has it taken steps to protect its intellectual property? Those are things you want to do in your pre-sale examination to understand. And if you have, in the purpose behind all this, right, is to be able to answer questions when the potential buyer comes in and has those questions. And also it helps, create a more valuable business if you have good answers to these questions, because these are the issues where buyers take a look at and they try to say, oh, well, we assume this or we assume that. And so now we got to retrade on the purchase price type thing. So that's where this pre-sale examination becomes very, very handy and an important thing to do. Next, you might want to, if you're planning for the sale, is to hire an intermediary, right? So discuss, as I mentioned, well, I'll discuss this in a separate presentation, but that's, those questions I mentioned before, is finding that right intermediary that's going to help market the business. And then you got to prepare the marketing materials. And this is usually a combination of your intermediary and the business executives putting together, usually they have a teaser type sale document, which doesn't list the name of the company, but it just provides kind of general industry and a very high level financials in that teaser. And that's what's kind of provided to people in the market before they even sign an NDA or a confidentiality agreement, right? So it's just a teaser document. Again, doesn't disclose who the seller is or anything like that, but it's distributed by the intermediary to say, hey, who might be interested in this business? And then once you find those people that are interested, then you have them sign an NDA, and that's when they usually receive what a lot of people call the book, either the book or the SIM, confidential information memorandum, and that's going to be the full sort of document that discloses who the seller is, more detailed financials, and a lot of sales sort of language about why this is a good business to purchase, right? And so that's that comes up next, is putting together that book and distributing that out. Then you got to select the method of sale, right? Is it going to be a direct negotiation with buyers? Is it going to be an auction? How are you going to set that up? So that's another piece of starting the process. And then on the buy side, I would say if you're planning for a purchase, it's first you want to identify your goals of the purchase and create guidelines for the type of business that you're looking for, right? So what type of financials are you looking for? What size of a business are you looking for? What industry? Where is it located geographically? That's important because you may not want to move. And then when you have potential sellers on the line, you want to figure out what their motivation is for selling, right? So those are important questions that buyers are asking. All right, and then how do you begin the sale process, right? So we're going to SellSide, as we've kind of went over this, and this may be a little duplicative, but you're going to identify the potential buyers. You're going to get them under NDA, and then you're going to select a buyer, usually through an LOI, and then you start setting up the data room and providing disclosures. On the buy side, it's identifying potential sellers, signing that NDA, and then sending out your initial due diligence request list to try to figure out more information about the company, right? All right, so then we get into valuation. Valuation is going to be it really varies, and so it depends on the size of the business. A lot of times, the larger businesses that have larger value, it's going to be most of the time done on some sort of multiple of EBITDA or some sort of discounted cash flow. There's a number of ways that you might value a business. When you get to the smaller businesses, the business broker type deals, the under 5 million type deals, you're usually looking at seller discretionary income, or SDI, or seller discretionary earnings. It's also sometimes called seller discretionary income, but SDE is probably more often used. And so SDE is just what does the owner take away? So these are the type of businesses where a buyer comes in and they're going to own and operate the business, right? And so it's important for that person to know how much money they're going to walk away with each year, or have some understanding of that. A lot of times when the brokers or the investment bankers put together this number of seller discretionary earnings, they're going to have add backs in there. So a lot of times smaller businesses, the companies run certain personal expenses through the businesses. So they're going to say that's an add back, like, hey, I'm a seller and I have my daughter's cell phone paid for by the company. And that's not something that you're going to have to do moving forward. It doesn't really go to operating the business. So I want to add that back to increase seller discretionary earnings each year, because that's what you'd be able to walk home with that money instead. So there's a lot of potential add backs. Sometimes brokers get overzealous with their add backs. So you want to be careful on which ones you actually accept as true and which ones you say, no, that's a real expense of the business that I'm going to have to continue with. So that's something you got to deal with in valuation. All right. So then you start negotiating the deal, right? And you have what are going to be the price and terms of the deal. So a lot of times price is not the sole factor. Sometimes sellers are going to sell. I would say, especially in the smaller business context, it's the sale of a business is a very emotional decision. This is their baby, and they're going to look for the buyer that they like the best, the one that they think is going to treat their employees the best, and really has the opportunity to make the business successful in the future. So purchase price is not always going to be the determining factor, I would say, in smaller businesses. And the terms are very important too, right? So, a seller might be willing to take a smaller purchase price if they get more cash at closing. So if they have a deal, one deal to buy the business for $5 million, and one deal to buy the business for $4,500,000, but the $5 million purchase price comes with a $1 million seller note, and the $4.5 million one comes with all cash at closing. They may say, hey, I'll take the $4.5 million now, and rather than having the seller note that comes out and it's subject to you being able to run the business, the buyer being able to run the business in the future. So the terms are very important on that as well, not just the purchase price. And then you have an earnout, right? So is there going to be an earnout or not? That also is a function of the terms that may or may not. Sellers, I always advise sellers that, hey, the earnout piece of a transaction should be considered gravy. There's a lot, I've seen very few earnouts structured in a way that it was a guaranteed pay, right? Where you're going to for sure get that payment in the future. There's a lot of usually contingencies on growth and the ability to increase sales or something like that. And if that doesn't hit, then the earnout's not going to get paid. And so it really should be considered as gravy in a transaction. And so that's, again, what goes to the fact that the terms of the deal are very important, not just the actual purchase price, end of the day purchase price. Then you got to negotiate, right, the structure of it. Is it going to be set up as an asset sale, stock sale? Is it going to be a merger? How are you going to set that up? And so that gets negotiated. And then, typically this all stems and culminates in an LOI, right? So LOIs are we're going to have a separate presentation just on LOIs themselves, but I always say LOIs are more of an art than a science, because you can have a very detailed LOI, or you can have a very kind of broad LOI that doesn't have a lot of specific terms in there. It just kind of generally discusses some of the major terms like purchase price, and there's no right or wrong way. I've seen a lot of private equity type buyers that come with a very not a very detailed LOI, and it's because they want to go through due diligence first before they lock themselves in. Because the problem is, I put in here LOI and retrades because retrades are very hard to deal with in an M&A process. So I say retrade is any time that we say something in an LOI, but then try to negotiate something different in the actual purchase agreement. So if we say, the purchase price is $3 million, and then we start due diligence and start working on the purchase agreement, and that buyer comes back and says, actually, after reviewing the due diligence, this business is really only worth, $2.5 million. That, from the seller's perspective, is going to be considered a retrade, right? And then that's going to cause a bunch of issues. And so, you got to be able to understand whether that LOI is going to allow for that or not. And also what assumptions that the buyer is basing their purchase price on, right? So that's good to understand in the very beginning, to say, hey, what are you basing your purchase price on? And if nothing that you're basing your purchase price on changes with your due diligence, then there shouldn't be any retrades. All right, so that's negotiating the deal. Then we get into due diligence, right? So due diligence is the process by where the buyer gets more information on the seller. They try to understand the business, where the potential issues are, and so they're walking into the deal with eyes wide open. This usually we have a due diligence request list, right? So that gets sent out. If we're representing a buyer, we're going to send out a due diligence request list to say, hey, can you please provide us with all these documents? And typically, this can be a frustrating process for sellers because they're saying, why are you asking me for all this? I've already provided you the book, the SIM, some financials. Why are you asking for all these other documents? And a lot of times, and they may say, hey, a lot of these don't even apply. And that's true. So most of the time, the due diligence request list is going to be a broad list of documents that we want the seller to affirmatively say do not exist. So if there's no patents, then affirmatively say here in this due diligence request list, when we say disclose all patents that you have, we want them to say NA, it's not applicable because we don't have any. But unless we have that, actual request and get that response, it's hard to have it documented to know whether or not they actually did not have those type of issues with their business, right? So that's kind of the backbone of the due diligence process and how it gets started. A lot of times there's a data room, right? So the data room is sometimes set up by the advisors, sometimes it's set up by the attorneys, sometimes it's set up by the selling company. They may have either a data room subscription, or they may have something like a Dropbox or a Box account where they put all their documents. So we have this due diligence request list. It has all this list of items, and they're usually labeled with numbers. And so the data room typically mirrors that due diligence request list. So it says, section 1 of the due diligence request list is your entity documents. Where are all your corporate documents? And so then in the data room, you'd have a folder labeled 1, corporate documents, and that's where you'd put all your corporate documents for the buy side advisors to review. And so that's how that gets set up. And then there's disclosure schedules, right? So any purchase agreement is going to have, most purchase agreements at least, are going to have disclosure schedules. And that's really ties to the reps and warranties in there. And it says, for example, you might have a representation and warranty in the purchase agreement that says the company has no current litigation outstanding or threatened against it, except as provided on disclosure schedule number, whatever disclosure schedule that is. So that's how the buyer can make that representation true if it actually does have litigation. So it could say, hey, in that disclosure schedule, we have one pending insurance claim. A slip and fall happened at our property, and somebody sued us, and insurance is handling it. So here's the caption of the case, and you list that in that disclosure schedule, and then now that representation is true, right? So you're saying we have no litigation other than what's put on that disclosure schedule. And so now if you sign that purchase agreement, that seller's not in breach because it has disclosed that. And it also allows the buyer to look into that more and ask more questions, right? So it can say, all right, you do have litigation. Well, what is the potential damages that are come from? Will it exceed policy limits? And if not, then maybe we're fine with it. If it is, then maybe we want to have a separate indemnification for that. It could change the way the contract's drafted. And then the other big piece about due diligence I see that comes up a lot is key employees, right? So when do the key employees, does the buying party get to meet the key employees? Is that typically the seller doesn't want to get the rumor mill started about a sale or people looking for other jobs, especially because if the deal doesn't go through, then they're stuck with this rumor mill that's going on and potentially with people who have found other jobs. And so, it's a very delicate topic. Sometimes the sellers are adamant to say, no, you can't meet anybody or can't address this with anybody until after closing. We want to be sure that we close first, and then you'll obviously be able to talk to the employees because they're going to become your employees. Sometimes the buyers are adamant about it. They say, no, we're not going to do that. We need to talk to these key employees because we don't want to buy the business if this person is not going to stick around, right? And so this is a very delicate topic, like I mentioned, and it's usually dealt with in the purchase agreement itself on when the buyer may have access to key employees. And then, just question here, we're talking about due diligence is all buy side due diligence. Is there such thing as sell side due diligence? Does the seller want to do due diligence on the buyer? And the answer to that is a lot of times no. There's not much due diligence to be done on the buyer. But if they are going to be holding a seller note, so if part of the transaction terms are a seller note where the seller is going to be paid the purchase price over time, then they may want to do some due diligence on that buyer. Make sure, one, that they think they can actually come in and run the company well and not run it into the ground. And two, do they have other assets that, are going to make it clear that they're going to get paid under that seller note. They want to have some confirmation that they can actually get paid. And so there might be some sell side due diligence on that buyer. All right, so now we've done due diligence. We've got a purchase agreement. Now we got to close this thing, right? So how do you close the deal? Well, first you got to come up with a closing date. You got to bring all these parties together to make sure everything's done by then, right? So the lender, there's a buy side lender, are they going to be able to have the money ready to approve and wire the money at closing? Got to get that all scheduled and get everybody on the same page on when this might happen. So that's the first piece. Then we have, closing documents. So a lot of times these agreements are set up like a real estate transaction, right? So you sign the asset purchase agreement, you have a due diligence period, and then you have a closing. So you could also set it up where it's a sign and close. So as soon as you sign the agreement, you close right then. But more often than not, they're set up as a sign and then later closing. And so what documents are signed at the closing, that's going to be things like the non-compete, the assignment of the lease, the transition services agreement, because these are agreements you can't really sign in advance of closing, because until that purchase price is paid, you don't want to sign the lease. That seller doesn't want to enter into a non-compete agreement. They don't want to enter into a transition services agreement until they know that the sale is going to close. So, those documents are usually signed and delivered at the closing. Other closing deliverables might be, third-party consents to contracts. Again, we talked about that earlier. If there's anti-assignment clauses or change of control provisions, you might have those those third-party consents to those assignments may need to happen at closing. You may need a payoff statement from a lender, right? So a payoff statement that says, on this XYZ closing date, the seller owes this amount of money of principal and interest under the loan. And so we're going to, here's the payoff letter that says at closing, this is what you owe us, right? And so usually that's when the wires go at closing, there's usually a wire that goes directly to that lender or creditor of the seller in that payoff amount. And then you got to make sure all the conditions to closing are taken care of. One of the conditions to closing is going to be that all the closing deliverables have been delivered and that all the closing documents are signed. But there could be other conditions to closing, like the buyer has a secured financing. And so that's another hotly negotiated topic in a purchase agreement, because the buyer or the seller doesn't want this to get strung out for a long period of time, but the buyer on the same time on the other side of the sword there, they don't want to close. They can only close if they get the lender on board, right? And so that might be a condition to closing, that they obtain financing. And so it's what are the rules around that? Do they have to? Can they not obtain finance all the way up to the closing date, or is there some period of time when they have to have that settled? So that gets negotiated in the purchase agreement as well. All right, and then getting close on time here, we have post-closing matters, right? So post-closing matters, there might be post-closing filings. You might be changing the name. So if it's an asset sale, for example, the seller may have the name of the entity of the seller may be the entity that's used out to in the public to market the company. If it's whatever, Bob's Pizza Shop, and the seller's entity is Bob's Pizza Shop LLC, then at closing, what has to happen is that selling entity changes its name with the Secretary of State, and then that buying entity either files for a trade name or changes its name of the buying entity to that Pop's Pizza Shop, right? So that it can use the name moving forward, because that's usually one of the assets in the transfer is that name. Then, from our side, we prepare a closing binder. So we put together all the documents, all the signed documents together in a closing binder, deliver that to the client, so they have one place to look for all the documents of the deal in case any issues come up later. And then, the other things to consider with post-closing is what is indemnification survival period, right? And we'll have a separate presentation on this and get into it in more details. But typically, all those representations and warranties in a purchase agreement have a survival period, maybe 12 months, maybe 18 months, maybe something different. But those reps and warranties are outstanding until that time is over. And so if there's a breach of reps and warranties that is found after closing, that's the period of time where the seller is sweating, right? To understand, when a potential claim can only come really during that survival period. So it's understanding what that is. Earnouts, seller notes, those are other post-closing items, making sure that they're being abided by. The earnouts are being paid if they're supposed to be paid, the seller notes being paid on time. And then, transition services. So how long is that selling entity or the selling principal is going to stay on and help transition the business, if at all? In some cases, it doesn't even make sense, especially if it's an absentee owner selling the business, then you may not even have a transition services. So that's the post-closing matters. And that's I think we're coming up on time here. Really, the takeaways here are that M&A deals are a process. They're complex. You want to form your team early, and you want to be ready for some ups and downs, because most deals feel like they're in the ditch at least once or twice in any M&A process. And so you got to be prepared for that. All right, 12:50, perfect timing. I'll open it up for questions. If anybody has any, let me know. You can raise your hand or put it in the chat. Benefits of fixed fees and M&A. Yes, so very, very good question. So the way we structure our engagements with clients is that we can do it hourly or we can do fixed fees. And so a lot of times, once we can get our hands around how the deal is structured, so we know, hey, this is an asset purchase deal. We're going to have a seller note. We're going to have an assignment of a lease. We're going to have a transition services agreement. We're going to have a security agreement. As part of that, we're representing the buyer, for example. So we're going to be doing the initial draft. Once we kind of understand how the deal is set up, we can provide a fixed fee amount that we would do the deal for. So we put together a statement of work and we say, hey, this is what you're getting for the deal. Here's the milestones that we need to hit to earn the fees and through the process. So for example, if whatever the fee is, if the deal dies in day one, we're not going to charge you the whole fee. Obviously, there's milestones to earn those fees. But the benefits of that, I would say, are that, and our clients have really enjoyed it, and we've really enjoyed it as well, because it really opens up the communication between us and the client. They're not checking your watch. You're not worried about how much time we're spending on it, or if we have two attorneys on the call or whatever. It's there's just a fixed fee for it, and we're there to get the job done right. And so we found that that's been very helpful for both our clients and for us as well, to be efficient in doing the deal. All right, I don't see any more questions coming through. Whoops, maybe did I see one here? Hold on. Nope, that's it. So appreciate everybody attending. We have this was the first in a series. As I mentioned, we'll have several others, hiring an investment banker or broker. We're going to be talking about another one called another presentation on LOIs. We're going to be digging deep into issues with due diligence. Then we're going to talk about reps and warranties and indemnifications. And then finally, we'll have a webinar on state and local tax issues. So again, one in a series. I appreciate everybody attending, and we will see you at the next one. Thanks.